Here from the appellant.
Yes, Your Honor. Thank you. May it please the court. Good morning, Your Honors. Amish Karani with the Knox and Campbell County Bar on behalf of Deer Hill. I've advised Deputy Clerk before. I would respectfully request reserving 6 minutes for rebuttal.
About 5 is about the most we'll let somebody say for rebuttal.
Yes, Your Honor.
But 5 will be fine.
Thank you. May I proceed, Your Honor? Your Honor, respectfully, the trial court's decision that, and the order of the trial court that has been entered, in this case, runs afoul with the statutory scheme that has been put in place as it pertains to these issues, and more specifically, 4866-102 et sec. Deer Hill, Your Honor, is not oblivious to, contrary to what has been suggested by the plaintiffs, on what the statutory scheme requires. And there are, of course, two components to the statutory scheme as far as what information should be made available and what information is subject to the additional burden of proving good faith. But Your Honor, what is also, what can also be discerned from reading the record is that the grievance that the plaintiffs have in this case, and the information that they're soliciting or requesting to obtain, most of that information falls within the purview of the second aspect of the statute, which requires them to show good faith. And really, if you look at the request, the only good faith that has been put forth, Your Honor, is for quote-unquote ease of mind. Your Honor, if that is satisfactory of the good faith requirement that is required by the statute, I would submit that you might as well just leave the statute aside, because there's no other way for, in this case, Deer Hill, the association, to fulfill its burden as required by the statute, and more specifically by the statutory scheme and case law. And I'm referring to the case of City of Franklin. City of Franklin Court, Your Honor, went through and analyzed cases from various jurisdictions to determine who has the burden to prove that the request is improper. And the city of Franklin and the Hillvale case were able to ascertain that the burden, in fact, is on the association to prove that the request is for improper purpose.
Mr. Karani, are you saying that these homeowners do not have the right to see the charter, the bylaws, the resolutions, and the minutes?
No, Your Honor, I'm not saying that. Whatever is in the first aspect of the statute, they're clearly entitled to. But what I'm also saying, Your Honor, and as I've put in my brief, the grievance that the plaintiffs have is with the governance of this association, and the governance of this association based on the master deed, which is a public record. It's recorded. It has been made available. It is everything that all of the information that they're requesting under one without showing good faith has been made available numerous times based on the affidavit and the record affidavit of Paula Lejeune and Surgeon, which is part of the record. But Your Honor, what the plaintiffs are trying to foster is a mindset, a preconceived mindset, I must say, that somehow the association is a predator and the homeowners are victims. And I would submit to you that that absolutely is a preconceived mindset, and it should not be furthered, because the issues that the plaintiffs have, and that's part of the record, is with the governance of the association. Based on the master deed, which is part of the record, which they have, which everybody has, the governance of the association based on the master deed is to remain with the developer, Park Properties. And if they have a grievance, Your Honor, there's a whole different line of analysis under the inner images cases and that progeny of cases that require developers to turn over HOA, regardless of what is being said in the governing documents, under certain situations are met, and that's when, in the inner images cases, is when the court adopted, for the first time as issue of first impression, the servitudes and requirements on when developers have to turn over the HOA. That has absolutely no bearing on what we have. In this
Well,
case...
maybe though they don't know if they have a grievance until they can see these documents to figure out if they have one or not.
Well, and that is no problem, Your Honor. But what the association has is a duty to establish under the statute that they have presented good faith for this request. And I mean, if good faith request is that we want to topple the developer, I mean, what has happened in this situation is that the association has not even been afforded an opportunity to present an opportunity to meet the burden. We've not been allowed depositions. And what has happened is the plaintiffs have taken the shotgun approach. From the inception that there's been a delay on the part of the association, and what they're trying to convey is that this delay is because the association is hiding something. Your Honor, that absolutely is not meritorious of any consideration at this point. And that is exemplified, in fact, Your Honor, by the statement that has been put in the brief. And this is not my word. I'm going to read verbatim from the plaintiff's brief. Sometimes the most telling story is the one that is never told. That is true for the association. Your Honor, if that does not, one statement in and of itself, does not warrant the fact that the association is absolutely entitled to be able to take depositions to establish good cause and to present that before an adjudication has been made as to whether there is a good cause for the information that they're requesting. And most of the information that they have a grievance, like I've mentioned before, is governed under the second part of the statute, which requires a showing of good faith. And the only showing of good faith that we have here is to put their minds at ease. Your Honor, there have been affidavits of Paula Lejeune, of Kelly Surgeon, that this information has been provided to them over and over again. Most of this information that is not subject to the good faith requirement is public record. It's public record. They have it. What is also important is that the plaintiffs have chronically been delinquent to the tune of $9,000 in their dues as of 2023, based in the affidavit. And the
Do you have to be in good standing with the HOA to take advantage of the statute?
No. I've never said that, Your Honor, but what I will say, though, Your Honor, is that the argument that they're saying is that we stop paying when they refuse to provide documentation. And that is absolutely incorrect based on the affidavits, because they have never paid from day one. They have made every story. They've tried to get explanations, which is all part of the affidavit. It's all part of the record. All of the questions have been answered. I'm not suggesting the reason for holding the information is because they're delinquent, but that raises a whole new level of scrutiny, Your Honor, because when you have all of this information, I mean, and your grievance is, well, you've not had a chance to vote. You've not been part of the board, but, well, I mean, that documentation you have access to. That's been given to you. So really, if you try to establish what the proper purpose is, clearly the proper purpose is, their grievance is, they want to topple the regime.
Why is that not a proper purpose?
Well, it could be a proper purpose, but, Your Honor, we're looking at information. So the association has information that is governed under the second part of member list. I mean, are they going to go solicit members? I mean, I'm not suggesting whether it's proper purpose or not. What I'm suggesting, Your Honor, is for the association to put on an argument and to meet its burden, which the City of Franklin case and the City of Franklin case addressed for-profit. I've not been able to ascertain a case that addresses not-for-profit, but the burden is on the association. But the City of Franklin and Hillwell, both of those cases were adjudicated after they were given a chance to take deposition and discovery. In fact, Your Honor, if you look at the case, and I've cited this, both of those cases, The court noted that the very little factual proof was introduced by either party, although both had the right and opportunity to offer such evidence. That was fatal. We have not been provided that opportunity. We asked for
Mr.
that.
Karani, they asked for several things in their request. Do all of them fall under subsection B? It looks like some of them may have fallen under subsection A, which didn't even require the good faith showing.
Yes, Your Honor, absolutely.
Were those items provided?
Yes, Your Honor, those items were provided based on the affidavits. And in fact, if you look at the technical record, pages 238 to 279, in addition to both the affidavits that we have, that information not only is public information, but they have access to Facebook pages, they have access to all of that information. Your Honor, the developer has not relinquished control of this association, and there has been no ruling to the contrary. The incorporating documents, the master deed, still allows the developer to be in control. That's probably the end of my time, but.
Well, let me ask you.
Yes, Your Honor.
I didn't quite understand the answer there to the question of whether or not your client furnished those documents, or whether you're simply saying, well, they're all out there in public records.
And Your Honor, is that referring to the first section
Yes.
of the documents?
Yes.
Yes. Our position is that whatever we have has been furnished.
That they did furnish them to them, not just that they can get them as a matter they're already out there on the.
Correct. Pages 238 through 279 of the technical record has those information, has the information that we submit is what we have, in addition to everything that's public record. In fact, Your Honor, the master deed that sets out everything was in fact attached, as, if I remember correctly, to the complaint that was filed in this action, so they clearly had that. And we're not talking about a layperson, Your Honor. The plaintiff, Ms. Lamothe, is a realtor. I mean, sure, God, she knows how to look up covenants and things of that nature, but it's all out there in the public domain, and in fact, they have it.
Well,
It has
again,
been
but
provided. Yes.
yeah, the question, did your client furnish them to them, or just say it's out there in the public domain?
No, that was given to them, and there's emails.
That your client furnished those documents to them? The
Correct.
answer to that is yes.
The answer to that is yes, Your Honor,
Okay.
and it may not have been after the complaint was filed, but it has been given to them before that numerous times based on what's been part of the record and based on the affidavit, yes.
What was provided in addition to matters that are of public record? What specifically was provided?
There were, Your Honor, and I'd have to refer to the technical record, but there were budgets, I believe, there was financial information that it doesn't fall under the purview of the first portion, but regardless, those were communications that were made with other members. All of that was provided. Everything was, and that's all 238 through 279 of the technical record. There were emails, correspondence, there were budgets, that whatever was prepared by the association that was given to other members was given to them, and they had access to it.
Thank you.
Yes, Your Honor.
You have your time for rebuttal.
Yes, Your Honor.
We'll hear from the appellee.
Good morning, Your Honors.
Good morning.
May it please the court, my name is Stephen Taylor. I represent the plaintiffs, Janine Lamothe and Matt Davenport, who are also present here today. I want to go ahead and address a couple of issues that were just raised before I dive into what I was going to say. First and foremost, no records have been provided to my clients. There has not been a single meeting minute. There's not been any list of who the directors or officers are. These are basic corporate formalities that anybody should be able to readily produce. None of that information has been provided.
All right, just so I'm clear, you're saying that the Homeowners Association did not provide any records to your client?
The only thing that
did they provide any records to your client?
they've provided emails.
So the answer is yes.
Yes.
All right, they did provide some, and what you say all they provided was?
All they have given us is some budgets on, hey, we're going to buy some new lounge chairs for the pool. Here, we're going to do this. We're going to do some landscaping, things of that nature. We have not gotten any real detailed financial statements. More importantly, we have not got any meeting minutes. There's not been a single annual meeting that our clients are aware of. And this is exactly why they grew concerned and made the request in the first place. They're paying HOA fees, and they want to know, where's our money going? Who is
Have
making...
they paid them?
And that raises the second issue. They were paid in full at the time they made the request, but after the HOA failed to give them the records, their position was, why are we going to continue to pay somebody when we can't even get transparency or records on where our money's going and who is making these decisions? And that also brings it back to, Mr. Carani had referenced the technical record, pages 238 to 279. I would encourage the court to go back and look at those pages. It's, 41 pages? That's all they have provided over the course of 3 years. By statute, we're entitled to records going back as far as 3 years. And 3 years, all you can give us is 41 pages of what the HOA has done. I think that says it all.
Before you get into sort of the substance of your argument, the order in this case, does it comply with the Smith requirement of findings of fact and conclusions of law?
I truly think it does, Your Honor, because I think this case is really simple, and the fact that, and you had mentioned it earlier, Your Honor, that under a certain provision of the statute, and I can cite it, that certain requests, all you have to do is make the request and you're entitled to the records. It is undisputed that we have made the request and we have not gotten the records. So I don't know how the court could go any further than that.
So you're saying because of the nature of this case, this order, which really doesn't provide any findings of fact at all, it just says a request was made and I'm ordering that they do X, Y, Z.
Based on the nature of the case, yes, I think it does.
All right.
And one other issue before I jump in, Mr. Carani had raised the issue of he needs discovery. Again, we have to separate, there's two categories of documents, some of which all we have to do is make the request and we're entitled to. And that applies to, I think, about 75% of the requests that were made. Then we come back to the good faith argument and his need for discovery. This case was filed in June of 23. We moved for summary judgment in October of 23. The case was ultimately set for an initial hearing in December of 23. It was ultimately heard by the court on January 29th of 24. They had more than 6 months to take any discovery they allegedly needed. They could have sent a deposition notice. They could have sent out written discovery requests. They had ample time to get any information they needed. The only time that the issue of discovery was ever raised was on the brink of trial in January of 24. So I would like to go back and just kind of highlight, I guess, some of the facts. Again, after purchasing a condo, plaintiffs, they have never received a notice of any HOA meetings. They've never received any information about who the board of directors are, and I could go on. And that's where this case started. After 3 years of not receiving any information and the bylaws specifically directing that there's supposed to be an annual meeting of March of every year, plaintiffs started growing concerned about their investment and wanted information about the HOA and the HOA's failure to observe the most basic corporate formalities. In an effort to hopefully alleviate those concerns, plaintiffs wrote a letter to the registered agents of the HOA requesting records on November 4th of 2022. The HOA never responded to that letter or even acknowledged it. And I think this is a perfect time to highlight, if what Mr. Carani had said was true, that these records had allegedly been provided, surely the HOA would have responded and said, hey, we gave you these records on whatever date. Here's what we gave you. The fact that they never did that, I think, says everything. After not receiving a response, plaintiffs then hired counsel and made another request for the records on February 28th, 2023. Again, no response from the HOA. On March 13th, 2023, plaintiffs' counsel sent one last follow-up letter to the HOA, giving them a deadline to respond by March 20, 2023. Again, no response. As a result of the HOA's failure to respond and abide by its obligations under the Tennessee Code, plaintiffs filed the application on June 14th, 2023. And again, as I said before, there are two classes of documents, one of which you just have to make the request and we're entitled to and get them. The other one does require a showing of good faith, and I think we have met that burden. I think any reasonable person, if you're paying HOA fees, you don't have any annual meeting in 3 years, you don't know who the board of directors are, you can't get any information from the HOA, I think everybody would grow concerned about where's my money going, why am I paying you? Basic questions.
Circling back to my question about the sufficiency of the order, I know you said that it was sufficient under the first part because if you just request, you get. What about under the second part that does require showing of good faith? The trial court doesn't say anything in the order about that.
Well, and I think that's the problem. The problem I guess I have is it doesn't, but the problem I have is the HOA's entire case seems to be that we've already provided the records. Again, no amount of discovery could ever change that. I think it's as simple as if the HOA had allegedly provided it, again, they could say, we gave you this is what we gave you, this is when we gave it to you. The fact that they have not said that, I don't know how any amount of discovery can change that. If that's their sole position is because we already gave it to you, there's nothing else we can do, clearly the HOA would have been able to furnish that information. And at the end of the day, the Tennessee Code Section 4866-104 requires that the court rule on this type of application on an expedited basis. I think the Chancery Court fulfilled that obligation. We would just ask that the court remand this case, affirm the court's decision, remand this case back to the Chancery Court so that our clients can obtain the records, and then we can pursue a motion for attorney's fees, because the HOA, candidly, they had no basis to appeal 75% of the request to this court because we're entitled to those records without any showing of good faith, regardless of whose obligation it is. So that would be my request, and I'm happy to answer any questions that anybody may have.
I hear none. Thank you.
Thank
We'll hear
you.
from the appellant rebuttal.
Your Honor, citing the case of Hillvale Corp., and that's a Tennessee Supreme Court decision, states both by pleading and by proper proof to establish an improper or illegal purpose so as to justify its refusal to make available the books and records requested. And Your Honor, emphasis on by both pleading and by proper proof. That is the burden that the association has, Your Honor. I was dropping my son yesterday to school, got a hand on a candy and wanted to eat the candy in the morning. And, I had my paternal duties to suggest no, especially more so with my wife being a dentist, to have that conversation with her in the evening about why he ate candy in the morning. I said no. His argument was just because I want it, I should be able to eat it. I'm not suggesting my kids are not disciplined. They're perfect kids, excellent.
I'm not disciplined. I routinely have a piece of candy for breakfast along with my coffee, but anyway.
Your Honor, I've got a dentist wife, so I have, my standard is a little higher. But what I'm suggesting is that's kind of the argument that opposing counsel is making, is just because we ask for it, you just give it to us. Just give it to us, and the whole...
Well, that's because that's what the statute says.
Well, the first portion of it, and our argument on that, Your Honor, submitted to you that we've given that information. What we have has been provided to them. What I'm referring to is the second, which requires us to, like the court said, is the burden's on us, Your Honor. We have, and this whole idea that they're trying to suggest that, and again, it's a preconceived notion that they're trying to suggest that HOAs just need to be villainized. And that just absolutely is not true, because HOA holds information that is confidential to a certain extent about other members and being solicited. I don't know, and which is the reason why the statute provides for the safeguards. I mean,
Mr. Karani, let me ask you, what is your position on the sufficiency of the order in terms of whether it makes findings of fact and conclusions of law?
It doesn't. I mean, I've put that in my brief. I've raised that specifically as an issue, and I was not going to suggest any more than the fact that there's nothing else to argue about that. It just doesn't satisfy the requirement under Rule 56 for that purpose, Your Honor. But what is also important is this shotgun approach that the plaintiff has taken. Is that, there's a delay, villainize the association, pin everything, all the delay on them, and then somehow raised, like they have in this brief, they have said about something about stories not told. That sentence alone, Your Honor, should entitle us to discovery, I would submit. But
Did you request any discovery?
Oh, Your Honor, how am I to request discovery? The complaint gets filed, they file a motion for summary judgment. Now, opposing counsel mentioned that they should have done this and that, the other, so I'm assuming they're conceding to the fact that we are entitled to discovery. I'm assuming they're doing that because they're suggesting, just did, in fact, that they should have asked for depositions, which means we're entitled to it. Your Honor, what happened and what's apparent...
Let's go back to my question.
Yes.
So the answer to my question is no, you didn't request any discovery.
And I will answer that question in two parts, Your Honor. Answer is no, and the reason why is because they did not comply with Rule 56. They filed a motion for summary judgment without statement of concise, undisputed material facts. That's not in compliance, and I filed a motion. Your Honor, all the delay is not on the part of the association. I mean, they didn't comply with the rules. And once a motion for summary judgment is filed, I file a motion to enlarge time to allow for discovery. I mean, the association has complied with Rule 56 and the requirements of Rule 56 as the record would reflect. But what is more important is the fact that opposing counsel has now submitted that if you had made that request, we would have allowed for discovery, we're entitled to it. Your Honor, if they would have made a proper motion for summary judgment that is supported by a state material dispute of concise, undisputed facts like Rule 56 requires, and I can't imagine that there would be any contest that they did because the record is abundantly clear that they did not. Once they did is when the motion to enlarge time was filed, because at that point we knew what they're contesting as being undisputed, which entitles us under Rule 56 to enlarge to get discovery. I mean, Your Honor, again, I would end by suggesting, or not suggesting, but I would end by submitting that the shotgun approach just really needs to be disregarded. And this whole mindset that the HOA needs to be villainized is absolutely not true. The statute provides for the HOA to establish there's good cause, and in fact, the Hillvale and City of Franklin case, which I would submit there's no opposing cases provided for or argued to the contrary by the plaintiff in their brief, so I'm assuming they concede with that fact, we're entitled to discovery on the second aspect of it, and we would request the court to overrule the trial court on those grounds in addition to the fact that the order does not comply with Rule 56. About 9 seconds, Your Honor. Be glad to entertain any questions that you may have.
I hear none.
Thank you, Your Honor. May I be excused, Your Honor?
Yes.
Thank you.
Our thanks to counsel for both sides. We appreciate your briefs and your oral argument on this.